Hello, everyone, and welcome to Uncivil Law. With the issue of impeachment in the air, I thought maybe we would turn to a case where an official was charged with bribery. This is not Donald Trump, but it is the case of United States of America versus Michael Kimbrew. In this case, Michael Kimbrew was a staffer for a congressperson. He solicited and accepted a bribe, but he's arguing it wasn't bribery because what he did not count as official acts. Very exciting. So we're going to read the details of this case and decide whether or not Michael Kimbrew is guilty of bribery. Let's read on. Michael Kimbrew appeals his convictions and sentence for attempted extortion by an employee of the United States in violation of U.S. Code and bribery of a public official in violation of U.S. Code. Kimbrew does not dispute that he took money in exchange for a promise that he made as a federal official. He instead argues that he promised to do the impossible, so his conduct falls outside of bribery. We are not persuaded, and we affirm. So just so we're keeping track, he doesn't deny that he accepted money. He doesn't deny that he's a federal official. He denies that it's bribery because what he promised was impossible, and so it totally doesn't count. Let's read on. In early 2015, Kimbrew worked as a field representative for then Congresswoman Janice Hahn. Kimbrew worked in the Congresswoman's Compton office, LA, which was located inside Compton City Hall. Corruption? Inside my Los Angeles? It's more likely than you think. Around March 2015, Kimbrew visited a medical marijuana dispensary in Compton called Green Legendz, with a Z. I'll try not to express my hatred or be biased against them as a result. Let's press on. He told one of the shop's employees that the business did not have the permits it needed to operate lawfully. He left his business card and asked the employee for the owner's contact information. Kimbrew later returned to the shop and said that if the owners didn't contact him soon, he would have Green Legendz shut down. So soliciting bribes, extortion, official corruption, just all kinds of fun times we're having here. The owners of Green Legendz ultimately met with Kimbrew at his office in Compton City Hall. Kimbrew explained that Green Legendz had a permitting problem, but that he could make it all go away. Always proud to say when someone says that to you, I can make it go away. Great. I'll make you an offer you can't refuse.
I'm going to make him an offer he can't refuse.
The owners understood Kimbrew to be asking them for money to help Green Legendz stay in business, but no money was exchanged at the meeting. Thereafter, an undercover agent of the Federal Bureau of Investigation contacted Kimbrew. FBI enters the scene. The undercover officer arranged at a meeting with Kimbrew at Kimbrew's office. They discussed Green Legendz' lack of proper permitting and how to prevent the business from getting shut down. Kimbrew stated that most of Compton's dispensaries were slated to be shut down, but there was a plan to keep 5 of them open. Kimbrew noted the discussions about this plan were ongoing as the relevant parties were still putting all the rules and regulations together. The officer asked whether Kimbrew could help to arrange for Green Legendz to be one of the 5 shots, and Kimbrew responded affirmatively. Kimbrew stated that for $5,000 payment, he would get Green Legendz a permit and to make sure no one bothers you. Kimbrew explained that he would talk to the city attorney and a local city council member and that the officer would have nothing to worry about at this point. So this would be an example of bribery. Money for service. Give me $5,000. I'll make sure your business doesn't get down. That's most decidedly very quid, very quo, very pro. It's very, very direct. Money, services. This is bribery. This is textbook bribery. We're doing great. Kimbrew stated that he wielded substantial influence due to his position. He oversaw the city of Compton in his capacity as the congressional staffer. He had a close relationship with city officials, including the city attorney. He had authority over the code enforcement and sheriff's department and had the ear of the congresswoman who could get the FBI involved in local issues. Well, as it turned out, Kimbrew was in fact right about one thing. He did have the authority to get FBI involved in local issues. I guess he didn't realize just how local those issues would be, though. In 2015, the FBI and Kimbrew had a follow-up phone call. Kimbrew noted that he had not heard back from the FBI since their meeting, and he was planning to close down the Green Legendz by the next Friday. He asked to schedule another meeting and Kimbrew agreed. They discussed Green Legendz permitting problem again, including a warning letter from the city attorney, and Kimbrew reaffirmed that all that I can make go away. He again committed to talking to the city attorney and to code enforcement to keep from interfering with the Green Legendz business. At one point, Kimbrew agreed the $5,000 payment was like a kickback. When you're saying that, presumably on tape, to the FBI enforcement, that's going to be a bit of a problem at your upcoming criminal trial, yes. Towards the end of the meeting, Kimbrew hedged because I'd rather not take your money today because I'd rather make sure I can deliver on your promise. Not quite sure why he's hedging, but he is, so okay. The FBI officer then passed $5,000 across the table, hidden under the restaurant menu. Kimbrew accepted the money. Nonetheless, Green Legendz was shut down a few days later. Well, he was hedging about taking the money, but when he was actually slipped the money, he was happy to take it. So FBI handed him $5,000 under an envelope. He took $5,000. Yep, that's going to be a bribe for you. Kimbrew was indicted on one count of attempted extortion by an employee of the United States and one count of bribery of a public official in violation of law. Following a jury trial, he was found guilty on both counts. Very sad. Kimbrew was sentenced to 18 months in prison, 3 years of supervised release, restitution in the amount of $5,000, and a $4,000 fine. Well, I suppose for a first offense, I'm assuming it's his first offense since he was a congressional officer and probably had to go through a background check. So for a first offense, 18 months is pretty high, especially if you've not done jail time. So I'm pretty sure 18 months got his attention. And the fact that he had to pay the money back and a fine was a nice touch. So you got that going for you too. Teresa Cunningham says, was it a setup? It was. You know, the fine people at the marijuana place apparently contacted the FBI, and the FBI decided to set them up. So, well, it wasn't a setup at the start. The start was, I want money. So it wasn't a setup from ground one. Someone called the FBI and the FBI got involved. So good for them. That's what the FBI should do. They're actually investigating a real actual crime. Wow, that's great, right? With that out of the way, Kimbrew is going to argue why it's totally okay, and he's going to argue why he's totally not guilty of these charges. So this should be entertaining and enlightening to all of us. Kimbrew argues the evidence was insufficient to support his bribery conviction. Specifically, he contends, the government failed to prove that he could make good on his promises, and therefore, he did not commit an official act within the meaning of the statute. So I couldn't actually get it done, therefore it wasn't an official act. Therefore, it's not bribery. Kimbrew's argument is both factually and legally incorrect. A public official commits bribery if he corruptly demands, seeks, receives, accepts, or agrees to receive or accept anything of value in return for being influenced in the performance of any official act. An official act is any decision or action on any question, matter, cause, suit, proceeding, or controversy, which may at any time be pending, or which may by law be brought by any public official, in such official's official capacity, or in such official's place or profit or trust. So by way of an aside, one of the issues with Trump and whether it counts as bribery or not is the issue of whether or not there was something at value at stake. Now here, it's pretty obvious because we're talking about $5,000 cash. That has a value of $5,000. But what Trump was potentially seeking, if you view what he was asking as a potential bribe, is the announcement of another official act. So he's trading official acts for official acts. And he was trading, and so that falls into issues of intergovernmental relations, falls into issues of foreign relationship, and also whether or not it's of value to him personally versus value to the United States is, of course, itself a debatable question. Unlike here, where it's $5,000 directly in your pocket, pretty clear, it's for you. So there's a whole bunch of issues, like, is information itself a thing of value? Is a visit to the White House a thing of value? If it's foreign relations, does that count as a thing of value? If it's for the United States, does that count as a thing of value? So there's a lot of factual, legal differences between Trump and that. So some of the issues that are at point there. The bribery recipient need not be the final decision maker. A public official may also make a decision or take an action on a question, matter, cause, suit, proceeding, or controversy by using his official position to exert pressure on another official to perform an official act. So that's a lot closer to potentially what Trump did, depending on your point of view of the reading the transcripts. But then, of course, you still have the international conflicts of it because it's, foreign state to foreign state issues. But that's a lot closer there. So too, a public official may be liable if he uses his official provision to provide advice to another official, knowing or intending such advice will form the basis for an official act by another official. Moreover, the bribe recipient is not required to actually make the decision or take an action on a question, matter, cause, suit, proceeding, or controversy. It's enough the other official agree to do so. The evidence shows that Kimbrew and the city attorney knew each other, and they both worked out of Compton City Hall. Although the city attorney denied that Kimbrew had any influence over him, the jury also heard recorded conversations in which Kimbrew attested that he did in fact have such influence. The factual dispute was a matter to be resolved by the jury, which could have reasonably believed Kimbrew's representations over the city's attorney's denial. On this record, a rational jury could have reasonably concluded that Kimbrew, in fact, had the ability to exert the promised influence. Similarly, the jury could have reasonably concluded that Kimbrew had the means of influencing the Congresswoman's actions. Finally, Kimbrew contends that it would have been impossible for him to help secure an operating permit for Green Legendz because marijuana dispensaries were categorically unlawful in the city of Compton. And that's why there's no marijuana in Compton today. Thus, his argument goes, there was no official act because permitting a dispensary fell outside any official's purview. It was not a matter either pending or which by law could be brought before any public official anywhere. The jury reasonably could have taken Kimbrew's recorded statements at face value and accepted as true the city had pending plans to permit a small number of marijuana dispensaries to operate. The statutory definition of official act contains broad temporal language that indicates the question or matter at issue need not be currently pending or be capable of being brought before a public official. It is true the contingency never came to be and Green Legendz got shut down. Regardless, the prosecution was not required to prove that Kimbrew could achieve the outcome he promised. The relevant inquiry, instead, is whether Kimbrew agreed to use his official position to exert pressure on another official to perform an official act or advise another official, knowing or intending that such advice will form the basis for an official act by another official. A contrary reading would run afoul of the process-oriented rather than results-oriented nature of the offense. As noted, the offense of bribery is complete upon the agreement between the briber and the public official. The Supreme Court has emphasized that the official need not go through to be found guilty. The official can be convicted even if he never intended to perform the official act of which he was bribed. In short, execution is immaterial. And so that is the end of the case of United States of America versus Michael Kimbrew. In this case, we learned that a person who was working for a congresswoman in the City Hall of Compton in LA was trying to solicit a bribe, and the FBI got involved, and they gave him $5,000 to make sure Green Legendz, the wonderful pot dispensary that is, would not be shut down. But alas, it was shut down. But it didn't matter because he had accepted the bribe. Regardless of his ability to execute on the bribe, he was guilty, and so the evidence was against him. And that is the end of this case.